The next case on the call of the docket is agenda number 125483, United States of America versus Jeremy Glispie. Ms. Ramos, you may proceed.
Good morning, Your Honors. May it please the court. My name is Colleen Ramey, and I represent the appellant, Jeremy Glispie, in this case. A friend recently told me one of the most important things she does as a prosecutor is to protect people's safety and security in their homes. The residential burglary statute serves as a tool to help her and her colleagues achieve that goal. Today's case presents a pure question of statutory interpretation, but this court's decision has the potential to fundamentally alter the way prosecutors charge crimes in the state and the tools available to them. We are asking the court to hold, consistent with the prevailing practice of lower courts, that the limited authority doctrine applies to residential burglary by entry. This conclusion is supported by the plain text of the statute, principles of statutory interpretation, and considerations of public policy. At the heart of the court's decision today is the meaning of without authority in the residential burglary statute. By way of illustration, consider three scenarios. First, a man walks into a grocery store during open hours with the intent to steal items from the store. Because this intent is inconsistent with the reason the store is open, he has now committed burglary because his entry was without authority. A second man is invited into a neighbor's home to borrow a cup of sugar, but once inside, he stabs his neighbor. If the state can prove that he intended the violence when he entered the home, his entry is without authority and he can be convicted of home invasion. Now consider a third man who is invited into his friend's home for a social visit and ends the evening by stealing cash and a TV set. If man number three intended to steal when he entered his friend's home, was his entry similarly without authority, and can the state prosecute him for residential burglary? We ask the court to hold that it can. The plain language of the residential burglary statute supports application of the limited authority doctrine. Indeed, for over half a century, this court has reasoned that where a defendant enters a premises with a concealed criminal intent, his entry is without authority, even if he has been given permission to be on the property for some other purpose. In other words, where authority is provisional and an intent inconsistent with that authority granted to an individual will vitiate the owner's consent. This conclusion was drawn from the plain text of the burglary and the home invasion statutes, which both include the identical without authority language. Indeed, in People versus Weaver in 1968, the court reasoned that the authority to enter a business building or other building open to the public extends only to those who enter with a purpose consistent with the reason the building is open. An entry with intent to commit a theft cannot be said to be within the authority granted to the patrons of a laundromat in that situation. This court explicitly extended the doctrine to private spaces in 1993, holding that when a defendant comes to a private residence and is invited by the occupant, that authorization to enter is also limited, and criminal actions exceeded that authority. This has been the plain text reading of without authority for over half a century in Illinois, and there's no reason to think that it means something different in the residential burglary context. However, going further, other principles of statutory interpretation also support this conclusion. The presumption of consistent usage suggests that where the same phrase appears in two statutes having similar purposes, courts should presume that it means the same thing each time it is used. And this court has said that courts should assume that whenever the legislature enacts a provision, it has in mind previous statutes relating to the same subject matter. Thus, they should all be construed together. We should construe the residential burglary statute, which was enacted in 1982, and adopted the same language used in the burglary and home invasion statutes, which were previously on the books. They all require this entry without authority. If the legislature had indeed intended to require something more, something closer to the breaking and entering, which was required by common law, it is reasonable to presume that it would have used different language rather than adopting the without authority language that had been clearly construed in the context of burglary, and even by that point had been applied to private spaces and residences in particular. The animating principle, as this court has noted, behind enacting a residential burglary law as distinct from simple burglary was to make residential burglary a more serious offense than the ordinary illegal invasion of other types of structures or enclosures in an effort to protect the privacy and sanctity of the home. The United States' proposition that the residential burglary statute restored the common law definition of burglary with this identical wording would require, as this court, to read into the statute limitations, exceptions, or other conditions not expressed by the legislature, which this court has been loath to do.
Counsel, can I ask you, with the legislature's addition of subsection A5 in 2011, did the legislature intend to remove the limited authority doctrine from subsection A?
I don't think this court can conclude that the legislature intended to remove the application of the limited authority doctrine. And in preparing for today's argument, I did reread that section a number of times and had the opportunity to think about it at even further length. Subsection A5 appears to be limited to falsely representing your identity. It adds this provision that says a person commits residential burglary when he or she falsely represents him or herself, including but not limited to falsely representing himself or herself to be a representative of any unit of government or construction, telecommunications, or utility company for the purpose of gaining entry to the dwelling place of another with the intent to commit a felony or theft therein. So it doesn't appear to extend to situations where you're simply deceptive about your true intent, but rather who you are and your position of some authority to be able to enter a home. The true function actually appears to be, and it's interesting because subsection A5 doesn't actually require an entry. It only represents this false representation of the individual's identity or some false representation with the purpose of gaining entry. So for example, if authorities arrest someone who has falsely represented himself as a utility worker and gained entry to a home only to steal from that person, they could charge him, assuming the limited authority doctrine applies to subsection A, they could charge him for that crime under either subsection of the statute. But if the authorities then find out that he has tried the same ruse on other potential victims and has been unsuccessful, so if he went to other houses and said, I work for the utility company and I need to get into your home for this reason, and they did not let him in, that would actually also fall, that those attempted thefts would also fall under subsection A5 as completed residential burglary offenses, because it appears from the language of the subsection A5 that the offense is committed as the false representation is made, and it does not require any actual entry into the home. I also believe that if we remove the limited authority doctrine from subsection A, we would be creating a hole of cases that would not be covered by the limited or by the residential burglary statute. So, for example, if someone falsely represents themselves as a utility worker and enters a home and steals from the inhabitant, they could be prosecuted under subsection A5. But if they're actually a utility worker and they enter a home, they represent themselves as a utility worker, they say, I need to come in, even if they have a legitimate purpose to enter the home as a utility worker, but they have the secondary purpose as they enter to steal, then that would not appear to be covered by subsection A5. And if the limited authority doctrine doesn't apply to subsection A, they could also not be charged for residential burglary under subsection A. So while I admit that there does appear to be some overlap potentially between subsection A and subsection A5, I think that it is reasonable to construe this provision as a belt and suspenders approach to legislating, particularly given that the same changes were made to the home invasion statute, which had incorporated the doctrine for almost 20 years when the amendment was enacted. But for the reasons I put forward, subsection A5 does appear to serve a different purpose than the limited authority doctrine does. Finally, public policy considerations strongly support application of the doctrine to residential burglary by entry. Across legal doctrines, it's recognized that individuals have varying degrees of an expectation of privacy in their private space in various places. However, the home is widely recognized as the epitome of the private space. Across this very consideration has led the Illinois legislature to decide that the burglary of a home is worthy of a greater punishment than burglary of other types of structures. Residential burglary is a class 1 felony compared to most simple burglaries, which are considered class 2 felonies. Similarly, if we think about the comparison between granting permission to someone, when we allow someone into our home, we're conferring upon them a very high level of trust, because when we make this simple act, we're at our most vulnerable. The violation of this trust with a concealed criminal intent is more morally culpable than walking into a grocery store during open hours with the intent to steal, and therefore deserves a more significant punishment. Thus, prosecutors should be afforded this tool under subsection A of the residential burglary statute to be able to make charging decisions and plea decisions with an eye towards the varying levels of culpability that could be present in a variety of residential burglary situations. Therefore, for all of these reasons, we ask this court to hold that the limited authority doctrine applies to residential burglary by entry in the same way it applies to simple burglary and to home invasion. If there are no other questions, I will reserve the remainder of my remarks for rebuttal.
Thank you, Ms. Ramus.
Thank you.
Mr. Simpson, you may proceed.
Thank you, Your Honor, and good morning to all of you, Your Honors. May it please the court, my name is Scott Simpson. I'm from the U.S. Attorney's Office in Springfield, and I represent the plaintiff Appellee United States of America here. I was actually somewhat surprised to hear defense counsel start with the plain meaning of the statute. That, of course, is where the court needs to start in interpreting a statute. But the language of the statute actually seems to require the prosecution to prove both unauthorized entry and criminal intent. It says a person commits residential burglary when he or she knowingly and without authority enters, or knowingly and without authority remains within the dwelling place of another or any part thereof, with the intent to commit therein a felony or theft. Again, that language seems to require both of those elements to be proven. The defense talks about the simple burglary statute, the home invasion statute, which do have somewhat similar language, especially in the simple burglary statute. But as I'll discuss, those are different statutes, and we believe actually very different statutes based on their history and purposes. And I'd like to talk about those things, and I'll also address the home invasion statute a little more specifically in a few minutes. So in relation to the residential burglary statute, I'd like to address mainly 3 areas: the history of the statute, the purposes of the statute, and its structure. And here I'll talk a little bit about the A5 subsection that Justice Burke talked about. All 3 of those considerations point to requiring the prosecution to prove both unauthorized entry and criminal intent. First of all, the history. Under the common law, burglary, of course, meant residential burglary, and it required proof of both of those elements. This court has said that the General Assembly enacted the residential burglary statute, which was in 1981. When it enacted the statute, it intended to restore to this crime the original status of the crime of burglary. This court has also said elsewhere that a criminal statute reflecting a common law antecedent, which this one does, of course, should be construed based largely on the common law understanding of that offense, and that it should be construed to effect the least alteration in the common law. And when the legislature enacted the residential burglary statute in 1981, the limited authority doctrine was expressly limited to public buildings. So there's no reason to think the statute was enacted with the limited authority doctrine in mind. Next, the purposes of the statute. Burglary, as defense counsel has discussed, burglary is different from other crimes. And residential burglary differs from simple burglary in the same ways. It's just a more extreme example of those ways in which burglary is different. Burglary is punished more severely than other crimes because unauthorized entry with criminal intent is inherently dangerous. And residential burglary is punished more severely than simple burglary because the danger is that much greater in the home. Residential burglary under the statute is always a Class 1 felony, whereas simple burglary of most buildings is a Class 2 felony. Unauthorized entry of a home with criminal intent is inherently unsettling, and it always entails the possibility of a violent confrontation. And because of those more severe penalties, the prosecution should be required to prove both unauthorized entry and criminal intent. The focus of the unauthorized nature of the entry is also why applying the limited authority doctrine to residential burglary would allow absurd results, which obviously are to be avoided in interpreting a statute. For example, let's say two women share an apartment, and one of them enters the apartment with the intent to steal her roommate's money, say from a kitchen drawer. Under the limited authority doctrine, her criminal intent upon entry would make the entry unauthorized, so she would be convicted of burglarizing her own apartment. And third, the structure of the statute. Here I'll get to the subsection A5. Residential burglary has two subsections, two substantive subsections, A and A5. Subsection A, the main one that I read earlier, is the one enacted in 1981. The legislature in 2011 added subsection A, which says, of course, that residential burglary can also occur if someone falsely represents themselves to gain entry with the intent to commit a felony or theft. So let's say we apply the limited authority doctrine to subsection A, which is what the defense is requesting here. If someone were to enter a home with criminal intent, the entry would be deemed unauthorized. That's the limited authority doctrine, no matter how it occurred, whether the person was a friend, if they had the criminal intent upon entry, or someone pretending to be a salesperson. Again, we're applying subsection A, or someone who forced their way in. If they had the criminal intent upon entry, it would be unauthorized under the limited authority doctrine. So if we apply the limited authority doctrine to subsection A, that would make subsection A5 completely unnecessary, surplus, which also should be avoided in interpreting a statute. So again, the structure of the statute also indicates that the prosecution should have to prove both elements. So to summarize those points, history, purposes, and structure of the statute, all of those support requiring the prosecution to prove both elements instead of applying the limited authority doctrine. Now, if I could turn to home invasion, the home invasion statute. Defense counsel has referred to that, of course. That's the only context where this court has applied the limited authority doctrine to private buildings. Other than that, it's just been applied to public buildings, stores, and so forth. Home invasion, though, is also very different from residential burglary. Unlike residential burglary, there's no intent element, only the unauthorized entry followed by a violent act or threat once the person is inside. That violent act or threat is really the focus of the home invasion statute. Applying the limited authority doctrine to home invasion simply means that we can infer a lack of authority to enter from the proven commission of one of those violent acts or threats listed in the statute. That seems fair to make that kind of inference for home invasion. In contrast, applying the limited authority doctrine to residential burglary would allow the prosecution to prove its entire case on a series of inferences. Let's say an example. Let's say a friend is invited into a home, and while there, he steals something. Without the limited authority doctrine, the fact finder might be able to infer criminal intent upon entry from the later commission of that theft, but they cannot prove unauthorized entry because the entry was invited. But with the limited authority doctrine, the fact finder can infer criminal intent from the theft, and they can infer that intent, that the entry from that intent, that the entry must have been unauthorized. So the entire case could be built on proof of the theft that occurred inside, inferring both criminal intent and unauthorized entry, both of the elements required by the statute. That does not seem fair. That does not seem consistent with the statute. So applying the limited authority doctrine to home invasion, which this court has done, does not mean that it should be applied to residential burglary. If I could,
So wouldn't the rationale be the same? I mean, in Bush, the rationale was that had the criminal intentions been communicated to the homeowner at the time of entry, it would have resulted from the person being barred. And therefore, it fulfilled the unauthorized entry element. Why wouldn't that apply equally to residential burglary, that rationale?
Again, Your Honor, I think Bush is in a little bit of an odd situation. That was home invasion. That was the one where they were, I believe that was the one where they were looking for someone who owed them money. And the limited authority doctrine actually wasn't applied there, I think. But I think the best answer to that is if there had been evidence that the entry was unauthorized, then they could have proven it. But again, I don't think that means that actually applying the limited authority doctrine to home invasion means that it should be applied to residential burglary. Now, if I could add some final thoughts about, defense counsel talked about public policy. If I could add some final thoughts about the ramifications of the court's decision in this case. The court should answer the question before it based on the language, history, and purposes and structure of the residential burglary statute. But the court should also be mindful of the ramifications of the court's decision. State and federal law work in tandem to provide appropriate and measured punishment. Greater punishment for repeat offenders discourages recidivism. A very common federal crime is the possession of a firearm by a felon. The federal punishment for that crime is increased if the defendant has previously been convicted 3 times of burglary, for example, as defined by the US Supreme Court, or of certain other crimes. Residential burglary, as we've discussed, is a very dangerous crime. Someone who commits residential burglary or other serious crimes in Illinois and then gets convicted of possessing a firearm as a felon should face greater punishment. But if the limited authority doctrine is applied to residential burglary in Illinois, some federal defendants will escape that greater punishment. Even from the standpoint, turning to the state courts, even from the standpoint of prosecution in state courts, public policy should militate against folding unauthorized entry into criminal intent for residential burglary. The state will likely be able to prove actual evidence of unauthorized entry as to people who are more culpable and thus worthy of the heavier penalties of residential burglary. People who are less culpable can be prosecuted under the simple burglary statute or some other statute, such as theft. For example, in the stabbing situation that defense counsel started with, the defendant could be convicted of the assault, or if death ensued, of murder. That would be the focus of the case without a need to resort to trying to prove burglary based on, or home invasion based on the limited authority doctrine. So if there are no further questions, Your Honors, we would encourage the court to answer the question certified by the Seventh Circuit here, which we appreciate the court accepting by holding that the limited authority doctrine does not apply to the residential burglary statute. Thank you.
Thank you, Mr. Simpson. Ms. Ramus, you may have your vote.
Thank you, Your Honor. The United States has urged this court to hold that residential burglary is not subject to the limited authority doctrine. But this holding would radically alter the prevailing understanding of the scope of residential burglary by entry statute in Illinois. And counsel has suggested that applying the limited authority doctrine would create results that border on the absurd. And I would humbly argue that really the opposite is true. Counsel has suggested that applying the limited authority doctrine would create some sort of slippery slope where people could be charged for burglarizing their own homes, such as by stealing from a roommate. If when they got home that day, they intended to take something from their roommate. But the statute, if a closer look at the residential burglary statute shows that there are safeguards in place to avoid such an absurd result. The statute requires that it be the dwelling place of another. And in 2015, the first district found that in People versus Larry, that they vacated a residential burglary conviction for insufficient evidence, where there was some evidence that the defendant was the live-in boyfriend of the victim. Even though, I mean, in that case in particular, he didn't have a key, and there was some question as to whether he was currently living there or she had kicked him out. But the bottom line is that that was not considered the burglary of the dwelling place of another. It was so I would object to counsel's characterization of the application of the limited authority doctrine as providing some sort of free-for-all on charging residential burglary to any theft of even from someone's own home. Further, it's worth noting that when you live in a home, you have basically unconditional authority to be there. You haven't been given any sort of limited authority to be in that space, which is really the genesis of the limited authority doctrine. I'd also like to address counsel's common law roots argument. Counsel suggests that if we look at the common law roots, that the statute's purpose, should return it to these common law roots, and that the limited authority doctrine is really inconsistent with those roots. But this argument, first of all, fails to account for the statutory context in which the legislation was enacted. When the statute was enacted, not only was it clear that without authority included the limited authority doctrine as applied to public spaces, but it had in fact been applied to private spaces in the Illinois Appellate Court. In 1980, the Illinois Appellate Court decided People v. Fisher, which explicitly upheld a burglary of a residence predicated on the limited authority doctrine. Second, and perhaps more compellingly, as the Appellate Court explained in People v. Walker, the limited authority doctrine is not actually inconsistent with the common law definition of burglary. In People v. Walker, it said, the court noted that while unlimited consent to enter is always a defense against a charge of burglary at common law or under statute, which includes in the definition of the offense breaking and entering or the use of force and entry, a consent limited as to place, time, or purpose is not a defense where the entry occurs outside the limitations stated or implied. So the common law never, as recognized in People v. Walker by the 3rd District, the common law didn't even recognize provisional consent to be in a location as a defense to a charge of burglary. I would argue that by excluding residential burglary from the application of the limited authority doctrine, it produces somewhat nonsensical or uncomfortable results. For example, if someone breaks in an office window to gain entry and steals something, they can be charged with burglary. However, if they break a window of a home, they can be charged with and steal something, they can be charged with residential burglary. That is the distinction that the Illinois legislature has made, and I don't think there's any question about that. Now, if we consider a situation where I give my friend keys to my office and ask her to go water my plants while I'm on vacation, and when she comes to water my plants, but she also brings a couple of garbage bags with her and takes some stuff from my office, she can be charged with burglary. Now, if the same thing happens, but I've asked her to water the plants in my home, under the government's reading, she cannot be charged with residential burglary. She can only be charged with simple burglary. Now, I would argue that the violation of trust is more culpable when I have asked someone to use, I have given someone unfettered access to my home. I have extended a greater amount of trust than my office, for example. If we don't apply the limited authority doctrine, we would also be excluding cases where, for example, if you hire someone to come and clean your home, and when you're showing them around, they see something that they think, oh, that looks good, I could get a good price for that. And then you leave your key for them, they come to clean the next time. And when they come into your house, they're planning to steal that valuable piece of property. We wouldn't be able to charge them with residential burglary under the government's reading. And this contravenes the practice in Illinois courts, the jury instructions as they're currently written, and just the way that practitioners in Illinois use this statute on a day in, day out basis. So a decision that my opponent suggests, a decision in their favor would dramatically alter the scope of residential burglary as it's currently understood in practice. And finally, I would humbly submit that the the consequences to federal defendants should not be a significant portion of this court's consideration of what is the actual state of Illinois law and what this statute actually means and was intended to mean, and how it applies in practice.
With regard to that last point, which is the ramifications that Mr. Simpson alluded to, could that be taken care of by a change in the federal statute?
Of course, Your Honor, yes.
Thank you.
Yeah. So for all of the reasons stated today and in the briefs before the court, we ask this court to hold that the limited authority doctrine applies to residential burglary by entry in, under subsection A in the same way it applies to burglary and home invasion. And it would provide a consistent reading of the Illinois law, and it is supported by essentially every consideration this court typically looks at when engaging in statutory construction. If there are no other questions. Thank you, Your Honors. I appreciate your consideration of this issue.
Thank you. Case number 125483, United States of America versus Jeremy Glispie is taken under advisement as agenda number 11. Thank you, Mr. Simpson and Ms. Ramirez, for your arguments this morning, and we appreciate you being here with us. Mr. Marshall, the Supreme Court stands adjourned.
Supreme Court stands adjourned.